So far in this series, we have already discussed DACA, the Deferred Action for Childhood Arrivals. We have also discussed the current litigation and the decision from the Southern District of Texas, which was issued in July of 2021, the case of Texas versus United States. In this video, we are going to discuss DAPA with a P. That's the Deferred Action for Parents of Americans, and the litigation that followed it. And we will get to that in just a minute. My name is William Kovatch, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. DACA is the program that President Obama created to address the children who were brought to the United States without documentation. DACA wasn't an overnight success. It took a while before people were willing to trust the government and to make their application. But once the benefits started being conferred and people saw that DACA was solving a lot of their day-to-day problems, DACA began to become more and more popular. One of the benefits of DACA was that DACA recipients could get work authorization. And once they had work authorization, they could get a social security number so they could pay taxes. Once they had a social security number, it was easier for DACA recipients to apply to schools and to apply for things like scholarships. It was also easier to do things like buy homes. People who were DACA recipients could now come out of the shadows. They could live something very close to an ordinary American life, however, without the ability to vote and without hope of ever really becoming a U.S. citizen. Now, with the success of DACA and with Congress stuck in inaction mode, that is, with Congress not doing anything either to pass DACA or to do anything towards any real immigration reform, President Obama decided that he wanted to expand the number of people who could benefit from this program. So, among the things that he did was he created DAPA with a P, the Deferred Action for Parents of Americans. President Obama also expanded Daca eligibility at this time, so that some of the dates that were set as deadlines, they were pushed back a bit. Now, without going into too many details regarding DAPA eligibility, essentially, it permitted undocumented aliens who were the parents of U.S. citizens or the parents of U.S. permanent residents to apply for deferred action. And if they applied for deferred action, they could also receive their work permits, their work authorizations, just like DACA recipients. And at this time, nobody challenged DACA through the courts. Nobody was challenging whether DACA was lawful. But for some states, DAPA was a bridge too far. So a group of states led by Texas challenged the DAPA program in federal court. They basically had two main arguments. The first was that DAPA violated the Administrative Procedures Act, or the APA, and the second was that DAPA was unconstitutional as a violation of the Take Care Clause found in Article 2 of the Constitution. Now, just a brief review before we talk about the APA claims. In modern times, Congress tends to create large programs where it defines broad policy goals but leaves the specific rules to the administrative agencies who are in charge of administering and implementing the program. And to govern how an administrative agency makes the rules, Congress passed the Administrative Procedures Act, or the APA. The APA requires an administrative agency to give the public notice of a proposed rule, and then the public must be given an opportunity to comment on that proposed rule. The agency must then respond to the public's comments and then alter the rule where that's necessary, and finally, a final rule will be published. In the end, the rule must be consistent as with the law that was passed by Congress, so it has to be consistent with those policy goals that Congress has passed, and it must be based on a permissible interpretation of the statute. Typically, all of this notice and comment is done through publication in the Federal Register. Now, as we noted before, DACA was never subject to notice and comment. Rather, one day, President Obama announced that he wanted to implement the DACA program, and then 2 months later, there were rules that were published on the USCIS website. Well, something very similar happened with respect to DAPA. Basically, the administration created a detailed set of criteria, and then that criteria was published again on the USCIS website without giving the public an opportunity to see a proposed set of rules or an opportunity to comment. The criteria that was published on the USCIS website determined who was eligible for DAPA and who wasn't, and it also defined how a DAPA recipient could possibly lose benefits. And DAPA recipients could apply for work authorization, that is, the legal right to work in the United States, which is evidenced by that work permit, or the EAD, Employment Authorization Document, which is essentially an ID card. And all of this was accomplished without publishing anything through the Federal Register. So as I stated, a number of states objected to the DAPA program, and Texas led the way. Texas and a number of other states filed a lawsuit in the U.S. District Court for the Southern District of Texas. And when the case was heard on the merits, they won. This included an injunction that prevented the government from implementing either DAPA or the expanded eligibility of DACA. The Obama administration then appealed the district court decision, and the appeal reached the U.S. Court of Appeals for the Fifth Circuit. When the Fifth Circuit decided the case, it essentially agreed with the district court. DACA, it found, was not a general statement of policy. It created benefits, rights, and obligations, and these benefits, rights, and obligations were subject to some very specific rules that were published by the Obama administration on the USCIS website. These rules limited the decision-maker's exercise of discretion. Now, whether a person was eligible for DAPA, this was not a decision that was made on a case-by-case basis. Rather, it was a decision made based on the eligibility criteria that had been published by USCIS on its website. Therefore, because DAPA was not a general statement of policy, it was subject to the APA. Pursuant to the APA, an administrative agency cannot act unless it has been given authority to do so by Congress through legislation. Moreover, an administrative agency's decision can be found to be unlawful where that decision or action exceeds the authority as has been given to it by Congress. The court continued that through the Immigration and Nationality Act, or the INA, Congress had created an express process through which an alien could qualify for benefits associated with lawful presence. DAPA was more than merely an exercise of prosecutorial discretion. DAPA did more than just promise the recipient that they would not be placed in removal proceedings. DAPA affirmatively granted benefits, specifically work authorization. And from work authorization flowed a number of other benefits. Benefits such as participation in Social Security and Medicare, as these were now taxes that would be automatically deducted from somebody's paycheck once they had gotten work authorization and a Social Security number. This, according to the Fifth Circuit, essentially granted a DAPA recipient a sort of legal presence, and it was a legal presence that was over and above that which was provided for by Congress through the Immigration and Nationality Act. Because DAPA went further than the Immigration and Nationality Act, it violated the specific scheme as adopted by Congress to govern how people come into the country legally. That is, it granted benefits beyond what the INA granted, and to recipients who had been denied benefits pursuant to the INA. So because the DAPA scheme was contrary to the very comprehensive scheme of the Immigration and Nationality Act, it was unlawful pursuant to the APA. In addition to its argument under the APA, Texas also challenged DAPA pursuant to the Take Care Clause of the U.S. Constitution. And that's in Article 2 of the Constitution, which addresses the power of the executive branch, the power of the president. Article 2 provides that the president must take care that the laws are faithfully executed. Texas' argument was that by not seeking the removal of DAPA recipients who were in the country undocumented without legal immigration status, that the president was failing to take care that the laws concerning the removal of undocumented aliens was being faithfully executed. Texas had won this point before the district court. However, the Fifth Circuit declined to address the point, saying that it had already disposed of the case by having found that DAPA violated the APA. The Fifth Circuit then enjoined the administration from implementing DAPA or the expanded version of DACA. The Obama administration appealed this decision from the Fifth Circuit to the U.S. Supreme Court, and the Supreme Court granted certiorari, so it heard arguments on the substance. But by this time, Justice Scalia had died, and the Senate was refusing to confirm the Obama nominee to replace him. Therefore, the court only had 8 justices. In this case, the justices were split 4-4, and because the justices were equally split, that meant that the decision of the Fifth Circuit stood. The DAPA case was resolved without any written opinion by the Supreme Court. The court merely issued a statement that it had been equally split, and thus the circuit court's decision was upheld. DAPA, therefore, died. The Fifth Circuit's decision in the DAPA case, therefore, is still controlling law. And because the decision from the U.S. Court for the Southern District of Texas is in the Fifth Circuit and therefore subject to its jurisdiction, this is why the current DACA decision that was released in July of 2021 is going to be difficult, if not impossible, for the Biden administration to overturn. Now, next week, we're going to talk about how the Trump administration then used the DAPA decision as the basis for its attempt to terminate DACA and how the litigation over that action turned out. In the meantime, leave a comment below on what you think of this decision by the Fifth Circuit. Give us a like, tell your friends about us, and subscribe so you don't miss our next video in this series. And as always, thank you so much for watching. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.